Hello, everyone, and welcome to Uncivil Law. Sorry for the delay and problems, but at least on my end, I have no dropped frames on YouTube. So I don't know why Twitch seems to hate me, but Twitch seems to hate me and YouTube doesn't. You know, I'm getting no dropped frames from YouTube, so I don't know. I don't know what's going on. I just look at this and say, well, seems to be working, so I don't know. So welcome to YouTube. Welcome to the Uncle Blackleaf stream. I hope you, as always, are having the most wonderful of days. And we're going to just give it a second and hope that people actually come over here from Twitch. You know, I don't know why I was getting... Well, now I'm still getting drop frames from this, too. I'm still getting 17% drop frames. Yeah, buffering. Great. Now I've got problems on YouTube too. 21% drop frames. Why is it this bad? There's nothing wrong on my end. VPN isn't running. Sometimes that interferes. That's not running. Network access. I'm connected through hardwired. Okay. I'm getting 20% drop frames even on YouTube. Why am I getting 20% drop frames? I mean, everything in the settings looks right. Hardware looks right. Audio, video, channel, output. I don't know. I don't know. I don't know what the problem is. I don't know what the problem is, and it's pissing me off. I don't know what the problem is. I can't figure it out. I can't figure it out. And I'm not going to do a stream with a bad connection because it's not good for you guys either. So no, Ewan, it's not. On my end, I'm showing 19% dropped frames. 19% dropped frames. And so, like, it's not buffering on your end. It looks fine. All right. Okay, we'll try to do a story. We'll try to do a story and see if it works. And if it works, then great. And if not, then we'll, I don't know, do something else. Because I don't like this, and I don't like it when it's not working. I want it to be good and good presentation. So, yeah, that's irritating me. Not buffering here, but drop frames are troubling. It's pretty fine on lower quality on YouTube. Drop frames are troubling. Yeah, I mean, it will be fine. It will be fine when I post the stories individually, because obviously I'm making a local recording, right? So there's no drop frames in my local recording. So when I ultimately go back to edit this for the streams, there won't be any problems. It just looks sloppy now, but obviously when I'm making the edits, I make it from the original recording. So, I'd say it's not perfect, but it's workable. Okay, well, we'll try workable. All right. We will try workable. All right. Greetings, hello Manitoba, how are you? You're missing 6 out of 30 frames every second, so not too bad. Okay, let's go with that. Let's go with the stuttered approach, and we'll just make it work. And at least it will be fine in post. So, we do what we can. All right, I'm just trying to load up our stories so we can get started. I'm sorry for the trouble in getting started here, but I don't know what the problem is, and we'll try to figure it out. All right. Okay, let us get started. Let's get started. A little head in the black box, yeah, that's kind of what we're doing for, yeah. All right, let's get started. Hello, everyone, and welcome to Uncivil Law. For today's story, we have a decision from the Court of Appeals for the Third Circuit. This is the case of United States of America versus Michael Lewandowski. In this case, Michael Lewandowski went to the FBI to report extortion against him. And as the FBI was investigating this, they came into information that he might himself be conducting criminal activity. So, the interrogation went from figuring out why he was being extorted to figuring out his criminal role. He then went on to be sentenced for his criminal misdeeds, and he is suing on the basis that his confession was not voluntary. So we're going to read the case, read the decision, and figure out why, when you're talking to the police, you should always have a lawyer. Let's read on. After Michael Lewandowski went to the police station to report that he was receiving extortionate threats, the police questioned him extensively about why he was vulnerable to extortion. As it turns out, Lewandowski, a pharmacist, had been filling fraudulent Oxycontin prescriptions. He later was tried for distributing a controlled substance. He moved to suppress the statements he made at the police station, arguing that they were inadmissible because no one read him his Miranda rights. The district court denied the motion, and he was ultimately convicted. As we're going to be discussing in a little bit, in more detail, Miranda applies in custodial interrogation. So in order to be read a Miranda warning, two things need to be true. You need to be in custody, and there needs to be an interrogation. To be in custody means you're not free to leave. To be in interrogation means that they're asking you questions or otherwise probing you for information. So both these things have to be true. If they're not both true, Miranda does not apply and they don't have to give you the warning. So we're going to read on about why Miranda was not given and why it was not necessary. Lewandowski appeals the denial of his motion to suppress. After careful review, we conclude that he was not in custody and therefore no Miranda warning was needed. Lewandowski was a pharmacist who owned 2 independent pharmacies in Medford, New Jersey. Around March of 2013, Lewandowski told 2 of his customers, Matthew Larson and Donna T. Jones, that he could no longer fill their OxyContin prescriptions. On June 18, 2013, Lewandowski received a series of threatening text messages saying things like, "Think about it, you're in too deep. Loyalty is the key. There's no I in team. Please consider my wishes or I'm forced to take other routes. It may be very detrimental." And, "I guess we're playing hardball. I really think you shouldn't sit and think you got a lot of dirt on you, Mike, and boy, you got a lot going on." Lewandowski also received a letter hand-delivered at his pharmacy that said, "No one is safe unless you meet our list of demands. Not your kids, family, you, your employee, Dave." The letter demanded thousands of OxyContin and Adderall pills, listing dosages and types, and $20,000 in cash. So this pharmacist apparently was caught up in a drug ring where he was filing knowingly fraudulent prescriptions. And as a result, when he said, "I'm going to start cutting you off," they took it not kindly. And so he's now being extorted. Let's see what happens next. The chats are appearing over the frame with you in it. I have no idea what you're talking about. Keaton, I have no idea what you mean. What do you mean the chats are appearing over the frame? What do you mean? Yeah, let me know what you mean. I don't know what you mean by that. Lewandowski contacted his uncle, a New York FBI agent, who in turn called in FBI's Trenton office. As planned, Lewandowski drove to the police department on June the 24th. He was interviewed beginning around 10:15 in the morning and remained at the station until 5:30. Because Miranda versus Arizona requires us to determine whether Lewandowski was in custody, given the totality of the circumstances, we recount the interview in some detail. Yeah. That's right, Evil Coleslaw. Yeah, it does. If you go full screen and mobile, then the chat appears superimposed over the window. That's how it's supposed to look. So if that's what you're talking about, then you're in full screen on mobile. It's supposed to look that way, as far as YouTube's concerned. Detective Nietzsche and FBI Special Agent Stephen Montgomery interviewed Lewandowski in a small 8x8 foot room that contained a round table and 3 chairs. It had the atmosphere of a bare bones conference room with carpet on the floor and typical office furniture. Lewandowski sat closest to the door and was not physically restrained. He was given water, which he drank, and offered pizza, which he refused. He went to the restroom, unaccompanied, at least 3 times. However, he asked permission before he went. Out of the 7 hours Lewandowski was at the station, he was interviewed for about 4. So this sounds like your typical run-of-the-mill interrogation room. Interrogation rooms are small. They're meant to create a series of unease. So they're small to get you to confess. So they're filled with furniture to make things a little bit more cramped. It's designed to like be physically imposing, so you want to leave, and therefore it induces you to say things that will be, revealing. So this is like a standard interrogation room. It's very bare bones, so there's nothing like interesting to look at. It's very, very plain. It's very small, and it's just designed to create you an environment which is conducive to the interrogation. So run-of-the-mill interrogation room. When you walked into here, you should have understood things were not going well. In the first portion of the interview, the officers obtained background information on Lewandowski and learned about the threats he had been receiving. Just before the first break, Detective Nitsch and Agent Montgomery excuse me. Let's try that again. Just before the first break, Detective Nitsch and Agent Montgomery spoke to each other briefly, and Agent Montgomery said to Lewandowski, "We'll be right back. Excuse me, do you need to use the bathroom or anything?" Lewandowski asked for a drink of water, and then left the room and re-entered with water. So we have phase one of the interrogation. The get-to-know-you comfort phase of the interrogation. Well-known police tactics. Most interrogations start without the subject matter at hand. Now, of course, there are exceptions to every rule. But especially like if you have this person, they're not really aware of what's going on. Like you didn't arrest them and bring them down. It's a little bit more like discontinued. This is very typical interrogation tactic. It's get to know you. It's build comfort. So like most interrogations start very casually. They start not on the topic at hand. It's very sort of like get to know you preliminary stuff and like, you're from wherever? Oh, I went there once on a vacation. Whatever. It's building rapport. It's building rapport that you can use throughout the interrogation, right? So that makes sense. We had phase one of the investigation. Very casual, get to know information we're interested about. You came down to report this extortion. So we're going to ask information that goes to the issue that you want to talk about. We're here to talk about what you want to talk about. We're here to make you super comfortable, and we want to talk what you want to talk about. So this is all part of the standard. That's phase one. Let's talk about phase two. The officers returned 20 minutes later, at which point their style of questioning shifted. Rather than listening to Lewandowski and asking clarifying questions as they had during the first phase, they asked pointed questions and suggested Lewandowski knew more than he was saying. Pro tip: when the police come and ask you to talk to them, bring a lawyer. Even if you're the victim of a crime, bring a lawyer. Just for the hell of it, just bring a lawyer, because you never know what they're going to ask, and the lawyer's there to help. So if you're talking to the police, even if you're the victim of the crime, bring a criminal defense lawyer, please. Just bring them there. It'll be great. It'll save you a lot of problems. Just do it. Please. Thank you. Detective Nitsch focused on the message that said, "I got a lot of dirt on you, Mike." When Lewandowski posed that the dirt might be a lie, Detective Nitsch responded decisively, "No, not a lie, Mike. Mike, stop. Everyone's done something and messed up. Everyone makes mistakes. What goes through your mind immediately when they say, 'I got a lot of dirt on you, Mike'?" Classic interrogation tactic. This is run-of-the-mill, classic, textbook interrogation stuff. Lewandowski eventually answered, "The only thing I kind of thought it was prescriptions." Agent Montgomery replied, "Well, that's what we were thinking." Whether they were thinking it or not, up to that point, confirming what you just said is a good police interrogation tactic. What does dirt mean? This is basically like cold reading tactics, right? Use general things to get stuff that you can then use to make specific, right? So it's basically the same stuff that mediums use in cold reading. I'm getting a J or J sound, and you say John, and then they say John, blah, 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 and you forgot they started out with the broad statement. All you remember It's well documented. All you remember is the specific thing. Oh, they said John. They came with John. They know. Well, they didn't. They started with a broad statement. The FBI is doing the same thing. It's basically the same tactic. You start out with a broad thing. What does dirt mean to you? And they say, well, it means prescriptions. Oh, well, that's exactly what we were thinking. How interesting. Tell us more about the prescriptions. And then you say, oh my God, the FBI knew about the prescriptions the whole time. Cold readers of the FBI interrogators. Using the same tactics, kids. Detective added, it sounds like you might have been, filling scripts for these guys. That would piss them off if you're not doing it. You have been doing it for a couple of years. Lewandowski asked, probably. Again, this could just be a guess. He's a pharmacist. They're talking about dirt. He just mentioned prescriptions. So yeah, it could just be a guess. And it would be a reasonable guess, right? Interrogators make guesses. And if you hit, they remember the hit. And if you miss, there are ways like cold reading to make sure that they don't remember the misses. Cold readers and the FBI are all about making you remember the hits and forgetting the misses. So they seem omniscient. Same strategies. So, John Edwards, FBI, kind of wanted the same thing. A few minutes later, Agent Montgomery said, so it appears on the surface that, to us, you could have been working with these guys. Now we're giving you an opportunity to tell us the truth. Lewandowski answered, I was not. I didn't have involvement with anybody. The officers also noticed that Lewandowski was making around $16,000 a month filling OxyContin prescriptions for cash. They said that would cause a lot of people not to ask questions because it's very lucrative, okay? Lewandowski continues to focus on his former employee, Wood. In response, Detective Nitsch said law enforcement was willing to do whatever we need to do to help you and try to help you and your family, but that Lewandowski needed to cut the nonsense. So the officers are appealing to his family, right? They're appealing to his empathy and saying, you have other people that need to be protected. And, for us to protect you, we need to understand what's going on. This is all meant to induce you to tell them things. The FBI is very good at this, as you might imagine. Please bring a lawyer with you when you're talking to the police or FBI. It's a good idea. After some time, Detective Nitsch told Lewandowski, September 2010, I opened an investigation on you that led to the arrest of several people. He went on to emphasize that Lewandowski was the subject of the investigation and Lewandowski's past activities had gotten him into trouble. But the fact of the matter is, you're not aware a lot of this, Mike, because you were part of the investigation. You were someone we were looking at and your involvement, okay? Now, after you've been doing this for the last 2.5, 3 years, it's come back to bite you in the ass because now you have someone or a group that someone are willing to do harm against you and your family. Again, not clear if this is actually true or not. One would imagine that if the FBI was aware of this in 2010, that they might have arrested him some point prior to 2013. So it seems like it's more indicative of bluff than of truth, but of course, it could be truth, and that's the whole point. It's like you don't know either way. And so it could just be a prod, an offer, a reasonable guess to induce something. And if it's a miss, great. And if it's a hit, great. Either way, we can deal with it. So were they investigating him in 2010? Who knows? But either way, it's good interrogation tactics. Detective Nitsch also told Lewandowski that taking these scripts, and not doing the checks that you should have done, it's not criminal. I'm not going to arrest you for it, okay? Yeah, as to the taking of legitimate scripts and not checking, that's probably not criminal, yes. And so they're not going to arrest him for that. Right. That's not criminal. They're going to arrest him for other things, but they're not going to make that point particularly clear. they're hoping that they'll hear, "We're not going to arrest you for it," and he's going to interpret that as, "We're not going to arrest you, period." That's not what they said, but, that's what they're hoping you'll hear, and so that you'll be more relaxed. Good strategy. Need some water. For those of you with me who are not college football fans and may not be aware of why I'm wearing this particular shirt today, I would just like to take a moment to say my Clemson Tigers victoriously destroyed Ohio State yesterday in the semifinals of the National Championship of Football in a very close game. I'm extremely happy about this. Go Tigers. So I'm wearing my Clemson shirt because my Clemson Tigers are victorious. Huzzah! The second break lasted 90 minutes. Then Detective Nitch returned alone and resumed the interview without any explanation for delay. He asked, "Anything you thought about while you're sitting in here for the last little bit that we're out there?" Good general opening question, just good. Just anything else you want to tell us about? I'm sure he's got questions of his own, but, hey, you've been sitting here for 90 minutes. What's been going through your mind? Anything you want to tell us about? It's good strategy, man. These guys are actually good. It's like they've done this before. Evil Coleslaw says he's a gamecock. Evil Coleslaw, I am deeply tempted to remove your moderator status as a result. I'm going to have to think about that one, man. Oof. Oof. The tone of the interview shifted again after the second break. Lewandowski made a series of lengthy statements about his circumstances and motivations, becoming emotional at times. He said he stopped filling narcotics prescriptions because the constant, every day, people coming in was relentless. The third break began abruptly. An identified detective opened the door just as Lewandowski was tearing up while saying, "I want my kids to be safe." Detective Nitch said, "I'll be right back," and walked out. He brought Lewandowski more water and then left for nearly an hour. Upon his return, he again gave no explanation, but said he was ready to go to the pharmacy with Lewandowski, as they had discussed. The two men left the station. Lewandowski drove himself to the pharmacy. Evil Coleslaw says, "I've had enough misery as a result of being a gamecock. No need to punish me further." No, you must be punished more for your horrible, horrible life choices. What part of calling yourself a gamecock did you think was a good idea, Evil Coleslaw, at any stage or point of this? What did you think, man? Jeez. Lewandowski also signed a form that day authorizing the FBI to record his telephone communications. The extortion case was eventually solved. Dante Jones and Matthew Larson were charged and pleaded guilty. So the FBI actually did investigate the extortion and actually did prosecute and convict the extortionist. So that's good. But of course, that's not the end of the issue, because the pharmacist himself, through his confessions, has given the FBI some information that can be used against him. And now he's facing jail time too. Let's discuss further. In November 2016, over 3 years after the interview at the police station, Lewandowski was indicted on 6 counts of drug distribution, 2 counts of maintaining premises for drug distribution, and conspiracy to In November 2016, over 3 years after the interview at the police station, Lewandowski was indicted on 6 counts of drug distribution, 2 counts of maintaining premises for drug distribution, and conspiracy to distribute drugs. He filed a motion to suppress the statements he made after the first break during the 2013 interview, arguing he was in custody and should have received Miranda warnings and that his statements were involuntary. After a day-long evidentiary motion, the district court denied the motion. Manitoban Mrs. says, "This just proves my thoughts on the police. Don't talk to them ever." Well, that's a pretty good tip. I would recommend modifying slightly by saying don't talk to them without a good criminal defense lawyer. You want a criminal defense lawyer, someone who actually goes. So as much as I personally would like to represent you, I'm not a criminal defense lawyer and don't necessarily believe I could do the best job for you. So you should get a criminal defense lawyer, someone who actually practices in this area. Say, the police want to interview me. Will you come to the interview? And they will say yes. And then you will have a meeting in advance and they will ask you all the stuff that the FBI will first, so they know the answers to the questions the FBI will ask. And then they will be prepared and they will say things like that's the end of the interview when they ask the question, because they will know what the answer is. So, bring a lawyer along when you talk to the police, please. The jury found Lewandowski guilty of 5 of the 6 drug distribution charges and 1 of the 2 premise charges. It acquitted him of the conspiracy. At sentencing, the district court found by preponderance of the evidence that Lewandowski had acted in concert with others. It sentenced him based on hundreds of fraudulent prescriptions rather than the 5 associated with the count of the conviction. By Lewandowski's calculation, the consideration of the additional prescriptions put his sentence into the 151 to 188 month range, rather than the 51 to 63 month range. The court ultimately sentenced him to 180 months. He appeals. Statements made to the police can be used against you. Very, very against you. Enjoy your time in prison. Lewandowski argues the district court erred in denying his motion to suppress the statements he made during the June 24, 2013 interview. He contends that his statements are inadmissible because he was in custody and therefore needed Miranda warnings, which he did not receive. Under the Miranda rule, the privilege against self-incrimination is jeopardized and warnings are required when an individual is taken into custody or otherwise deprived of his freedom by the authorities in any significant way and is subject to questioning. Custody is a term of art that specifies circumstances that are thought to generally present a serious danger of coercion. To determine whether an individual was in custody, first we establish the circumstances surrounding the interrogation. Then we ask, as an objective matter, whether a reasonable person would have felt that he or she was not at liberty to terminate the interrogation and leave. So when you're looking to custody, the issue is freedom to leave, whether real or perceived. And so you're looking to things like, well, would a reasonable person in the situation feel like they could leave? Did they say you're under arrest? Did they say you can't leave? Did they lock the door? Did they physically restrain you in any way? Or did they allow you, for example, to go to the bathroom by yourself? Did they allow you to eat and drink if you want? Did they leave you unaccompanied in an unlocked room for long periods of time? These would be things that would suggest more that you had freedom to leave. And if you had just left the door, you could have. So that's the kind of issues they're looking at. The court found there were never more than 2 questioners in the room with Lewandowski. No one blocked his exit, and officers used some salty language, but nothing out of the ordinary for a police department. The meeting overall was businesslike in tone. There was no posturing or shouting or pounding of fists on the table or any display of emphatic behavior. The court noted that 7 hours is a long time, but added there were 2 breaks and that Lewandowski had his cell phone and his normal clothes. Finally, the court observed that Lewandowski never indicated once he didn't want to answer questions. Instead, he gave hesitant answers or inconsistent answers. His demeanor on tape was that of a person who was deflecting the questions or pretending not to know the answers. We then moved to the second step of the Miranda analysis. Hold on, my display has gone completely dead. So there it goes. Great. Let's try that again. We then move to the second step of the Miranda analysis and ask whether a reasonable person in Lewandowski's circumstance would have felt free to go. Numerous factors help answer this question: the interviewee's location, physical surroundings and duration, whether he voluntarily participated, whether he was physically restrained, whether other coercive tactics were used, such as hostile tones of voice or displays of weapons, and whether the interviewee was released when questioning was over. We also consider whether the questioner believed the interviewee was guilty, whether the interview was specifically told he was not under arrest, and whether he agreed to meet knowing that he'd be questioned about criminal circumstances. So here the court is laying out multiple factors that can go to saying whether someone is in custody, which is to say whether or not someone feels free to leave. And there's a whole bunch of factors that can lead to that kind of conclusion. Now, not one of these things is dispositive, of course. They're all elements that a court can take note of in trying to determine whether or not a person is feeling free to leave. So these are guidelines. And you look at these elements and say, well, what factors are here, and would a person feel free to leave in this situation? And would a reasonable person feel like they could leave or had the ability to leave? And that's the question you're trying to leave. And that's the question you're trying to answer. To start, Lewandowski was not physically restrained. He did not feel an obligation to come to the questioning. And given the circumstances, we agree with the district court's finding that Lewandowski knew he'd be questioned about the reasons behind his extortionate threats, including his own possible criminal activities at the pharmacy. All these factors tend to show he was not in custody. The officers told Lewandowski they thought he might be filling fraudulent prescriptions, and when officers have more cause for believing the suspect committed the crime, there is a greater tendency to bear down in interrogation and create the kind of atmosphere of significant restraint that triggers Miranda. Here, though, the officers were trying to get to the bottom of extortion, so they needed to question Lewandowski about the subject of the threats. Therefore, the questions about OxyContin distribution do not show coercion associated with the custody. Zafel asks, dispositive, wouldn't that be negative? No, dispositive just means to dispose with the issue. Wow, let me try that again so I can actually put that in the video as part of the question answer, because I like to put them in the video. I like to not screw it up when I do. Let's try that again. Zafel asks, dispositive, wouldn't that be negative? Not necessarily. To say something is dispositive is simply to say it disposes of the matter, but doesn't say which way you're disposing of it. It just simply solves or answers the question. To say something is dispositive is to simply say we can dispose with asking the question because now we know the answer. So dispositive, at least in the legal sense, does not imply a negative or a negative connotation where we're saying it means it doesn't apply. It just means we know the answer one way or the other. So if we say, oh, this factor is dispositive and therefore says it's not something, or this factor is dispositive and therefore says it is something, either way it disposes of the question we're trying to ask. So thank you for the question. Evil Coleslaw says, it looks like he opened the books to them too. If they knew the interview, he's making $16,000 on cash. Well, I don't know whether they actually knew that number or whether or not they just threw out a number. I don't know whether that was a guess or an actual number. I don't know if they really were investigating him beforehand and did something or whatever. Maybe they threw out a number just to throw out a number and on the thought that they'd correct him. Maybe they said, we think you're doing $16,000 of business. And they'd say, no, I only did $4,000 of business. And therefore, they'd have a question as to four. So I don't necessarily know that because they said 16,000, that was an actual number as opposed to a made out number. But either way, it didn't matter because he confessed to the crime. So it worked. Great. Considering all these factors, the district court did not err in concluding that a reasonable person in Lewandowski's situation would have felt free to go. But even if we concluded the opposite, our analysis would not end there. Constraints on freedom of movement are necessary, but not sufficient condition of custody. The individual must also be subject to the same inherently coercive pressures as the type at the station house in questioning the issue at Miranda. So here the court is pointing out that one factor that you can look at is whether or not you felt free to go. And while that is necessary, it is not sufficient because you're looking to overall coercive effect. So you're looking to overall issues of custody. So not feeling free to go is necessary to be in custody, but not necessarily sufficient. And so you need to look at other factors. So let's read on. Jan, I don't care if you buy drugs or not, but you have to stay for the stream. So, sorry. Lewandowski next argues that his incriminating statements should have been suppressed because he did not make them voluntarily. The issue is not resolved by virtue of our conclusion that Lewandowski was not in custody. In special circumstances, a confession might be involuntarily even if the person is not in custody. Because you're looking to overall coercive effect, just because they're not in custody might not necessarily be a trigger. You could have a situation where the police are putting so much pressure on you or so much stuff that even though you're technically free to leave, that it still is unduly coercive. It basically shocks the conscience. And so that might be enough for suppression. Did that apply here? Let's read on. Zafel, I wouldn't necessarily recommend skiing and watching the stream at the same time. That seems like a bad plan. But whatever. The government has the burden to prove by a preponderance of the evidence that Lewandowski's statements were voluntary, that is, the product of essentially free and unrestrained choice. There can be no involuntary confession absent coercive police activities. We conclude by observing that Lewandowski is a mature and educated, sophisticated business owner who was in sound mental and physical health at the time of the questioning. Lewandowski's statements at the police station were voluntary. So that is the end of the case of United States of America versus Michael Lewandowski. In this case, we learned that Mr. Lewandowski was a pharmacist and was being extorted because he was no longer filling OxyContin prescriptions, including ones that he was fulfilling for cash money. And therefore, he revealed his part in the drug plot and was sentenced to 15 years in jail. He moved to suppress the evidence against him on the basis that the coercion was so improper as to require a Miranda warning, but the Court of Appeals disagrees, noting that the door was not locked, noting that he was free to go, noting that he was allowed to go to the bathroom by himself, and otherwise that he had his cell phone with him and could, and in fact did, make some phone calls during the interrogation, so that he was not under custody, and therefore Miranda did not apply. They did not need to give a Miranda warning, and all the evidence can be used against him and was used against him to the tune of 15 years imprisonment, and that is the end of this case. Well, Lewandowski instead of Lewandowski? Fine. Well, close enough for our purposes. Oh, well. Oh, well. All right. Ooh, this is a good one. Phone sex operator turned member of AmeriCorps got fired for it. Very exciting. Get to learn about retaliation for free speech. Good times. Mm. Okay. Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of Amy Harrensperger versus United States of America. In this case, Amy was a member of the AmeriCorps, a voluntary organization that allows people to give time to work in the United States to help cure poverty and other related things. Very good for her. However, in a former life, she was a phone sex operator, and she wrote a book telling her tales of her time as a phone sex operator. Her employer, a government agency, found out about her prior work and fired her because of it. In this case, we're learning whether or not she was properly fired or whether or not this was a case of retaliation for First Amendment conduct. So let's read on. Yeah, I won't put this part in the video, but yeah, the no I in team, but there is an imprisonment. Yeah, I did like that line from the last case where the extortioners, a part of their extortion said, "There's no I in team." That was a nice little touch. Yes, I did take note of that and remarked, yeah, all right. This appeal deals with the First Amendment protection for public employees when they engage in speech that is not related or tied to their work. Plaintiff Amy Harrensperger authored a short book published under a pseudonym about her time as a phone sex operator called Conversations with Monsters: 5 Chilling, Depraved, and Deviant Phone Sex Conversations. A month after publishing Conversations, Harrensperger began what was to be a 1-year stint with the Indiana Army National Guard as a member of the Volunteers in Service to America's VISTA program, a federal anti-poverty program administered by the Corporation for National and Community Services. But when Harrensperger's National Guard supervisor discovered Conversations and identified her as its author, She demanded that the CNS remove the employee from the position. Harsinger filed this suit alleging violations of her rights under the First Amendment and under the Administrative Procedures Act. The district court granted the defendant's motion for summary judgment. Harsinger appeals. We reverse in part and affirm in part. Conversations with monsters is clearly protected speech, and on this record, a jury could find the National Guard supervisor, Lieutenant Colonel Lisa Koplinski, infringed her free speech rights by removing her placement because of it. A little more, with that description out of the way, let's read a little bit more about her time in her former line of employment. A little more than a decade ago, Harsinger found herself unemployed and disgruntled with the thought of working for the man any longer, as she wrote in the introduction to Conversations. She decided to try phone sex work, but quickly discovered it was not the flirty fun the phone sex industry held it out to be. Harsinger was horrified to hear what some of the callers would fantasize to her about, including abuse of minors. These vile, unrepentant, disgusting, poor excuses for men and one woman are the monsters of whom she wrote in Conversations. Harsinger did not mince words. If you're having pleasure at the thought of a child, there's something clearly unfit for you in this world, and you need to end things once and for all. Conversations recounted 5 of the most horrifying phone sex calls and meditated on the social role of phone sex operators and her own experiences as one of them. Manitoban, if you teach me how to pronounce things, it will be less fun, because people seem to like it when I mispronounce stuff. So, yeah. Yeah. Shortly after publishing Conversation with Monsters, Harsinger was selected to participate in the VISTA program. The VISTA program is part of AmeriCorps, a federal network of hundreds of programs across the nation. It is sometimes called the Domestic Peace Corps. Harsinger applied to and was accepted as a VISTA volunteer sponsored by the Indiana Army National Guard. Harsinger was responsible for maintaining a database of information on service providers to whom veterans and their families could turn to for help. Occasionally, perhaps a dozen times over the course of 3 months, Harsinger was unable to find an item of information she needed, such as a service provider's telephone number or a physical address. In 2 such cases, Harsinger could find no contact information for the service provider at all, so using her own Facebook account, she posted a comment to the provider's Facebook page asking them for information that she needed. During her 3 months with the VISTA service with the Guard, these dozen contacts were the only occasions on which Harsinger interacted with members of the public on the Guard's behalf. Otherwise, she sat at a computer and entered data. So here, the protagonist of our story is collecting information for veterans on various services that are available. So her job is going forth and trying to find the information on all the services and consolidating them in one nice directory that people can find, so it makes it easier for them to find help. That's really good. And occasionally she found it very hard to find contact information for them. So as part of her duties, she would contact them directly, and on at least 2 occasions used her own Facebook page to send them messages to find out contact information for them. So, good idea, but unfortunately, that is going to expose her underlying previous work, as we're going to soon see. Jason, I refuse to call her Bob. We are calling her whatever version of her name is that I come up with on the fly, which need not be consistent from one pronunciation to the other in any way. So, I mean, I could call her Amy since that's her name, but that'd make it way too easy. We don't do that here. We badly mispronounce names. It's part of the fun. That likely would have been the story of Hargenschiffer's entire year with the Guard, but then Noelle Butler, Hargenschiffer's direct supervisor, asked to become her Facebook friend. Hargenschiffer felt that she could not reject this request from her quasi-employer. She accepted Butler's friend request and thereby gave Butler access to all of her friends' only Facebook activity. Harnish like harness with an ish. Harnish followed by Feiger. Feiger? Harnish Feiger? Harnish Feiger? Harnish Feiger? That sounds right, Dustin. Damn it. Now I have to pronounce her name correctly. Harnish Feiger? Damn it. I should ban Dustin. Shit. Butler explored Harnish Feiger. Butler explored Harnish Feiger's Facebook history deeply enough, through many dozens, if not hundreds of posts, to come upon her June 2nd announcement of the publication of Conversation with Monsters. Over her lunch break one day, out of curiosity about this bizarre title, Butler and another Guard employee followed the Amazon link and purchased a copy of the book. On September the 27th, Butler and the other employee brought the book's content to the attention of Lieutenant Colonel Kopsniak, the Guard's family program director. Kopsniak, whatever. Lieutenant Colonel Kopsniak wrote a letter to Amy Kublowski. Okay. Oh, man. All right. Oh. Breathe deep, Kurt. Breathe deep. Okay. Lieutenant Colonel Kopsniak wrote a letter to Amy Kublowski, a state program officer. Kopsniak requested that Harnish Feiger be removed from the Vista placement or terminated for early cause. Referring to conversations, Kopsniak explained that the activities and conduct found on Harnish Feiger's Facebook page did not favorably represent the Guard's family program office. Oof. Harnish Feiger contacted 5 of 22 potential sponsors for her. One responded, but it was far too from Indiana to be feasible on Harnish Feiger's limited means. Harnish Feiger thus failed to secure reassignment by a deadline. On that day, she received a second letter from Lopez informing her that her Vista membership had been finally terminated for lack of a suitable assignment. Just FYI, guys, are you having more fun now that I actually know how to pronounce Harnish Feiger? Are you having more fun now that I actually can pronounce it correctly? Is this better for you? Anyways. So we see what happened here. She was part of a program, and to be in the program, she had to have employment. She was part of this Indiana Guard in order to provide assistance to veterans. Her employer, who is a member of the Guard, a lieutenant colonel, fired her because of her prior work. And because of her prior work that was now exposed, she was unable to find any other employment in this program and so was terminated from the program. The requisite issue here is whether or not she was justly fired, whether or not her employer, a public entity, can fire her for her private speech. Let's read on. Harnis-Feiger sued Lopez, Kurbowitz, Kopsniak, and Butler in their personal and official capacities, as well as the United States government, for violating her rights under the First and 14th Amendment and the Administrative Procedures Act. To prove a First Amendment retaliation claim, a public employee must establish 3 elements. First, that she engaged in constitutionally protected speech. Second, that she suffered a deprivation likely to deter protected speech. And third, that her protected speech was a motivating factor in the deprivation, and ultimately, if a public employer cannot show it would have inflicted for deprivation anyway, the but-for cause. The first element, constitutionally protected speech, is the nub of this appeal. The second and third are uncontested as to Kopsniak. Whether a public employee's speech is constitutionally protected is a question of law, even though it may require predicate factual determinations. For clarity, we note constitutionally protected speech has 2 different meanings in this doctrine. A public employee ultimately satisfies the protected speech element of a retaliation claim by prevailing in a balance of the employer and employee interests required by Pickering versus Board of Education, 1968. So, as you would expect, this issue has come up before, when a public employer can fire an individual for conduct that is First Amendment protected or perhaps not, depending on the context. And the issue is there's legitimate interest from the state, but there's also legitimate interest from the individual in not being discriminated by the state on behalf of their First Amendment interests. So there is a balancing test, as announced in Pickering versus Board of Education, that balances these twin concerns, and so we're going to read a little bit more about this. The key issue under our precedent of NTEU are whether the employee's speech is made outside the workplace, involves content largely unrelated to government employment, and is addressed to a public audience, or if it amounts to the same thing, involves any matter for which there is potentially a public. So the first issue is whether it's made in the context of being an employee at work or concerning work matters, or on the other hand, is outside of work, concerns private matters, does not concern work. So that's the first issue of delineation. NTEU offers an easier and clear path to our decision. Harnis-Feiger's book was written and published a month before she began her VISTA service. Its content is completely and entirely unrelated to CNSC, VISTA, and the Guard. It was written for general audiences on personal experiences of sex workers and their social role, matters for which there's undoubtedly a public. Defendants tried to distinguish the case of NTEU by citing a case called Roe. What are the facts of this other case, Roe? The plaintiff in Roe was a San Diego police officer who sold videos of himself on an online marketplace, stripping and pleasing himself in a police uniform and pantomiming police work. For these actions and for failing to comply with the resulting investigation, Roe was fired. Police officer in police uniform selling videos of himself conducting self-pleasing activities for money. Seems like something the government might take some note of, yes. Although Rowe's expression purported to be unrelated to his employment, Rowe himself had taken deliberate steps to link his videos to his police work, all in ways that were injurious to his employer. The court pointed to the use of his police uniform in his performances, his elusive username, his disclosure of law enforcement employment, and his debased parody of an officer performing indecent acts while in the course of official duties, in finding that Rowe's expression brought the mission of the employer and professionalism of its officers into serious disrepute. Put differently, Rowe's expression was widely broadcast, linked to his official status as a police officer, and designed to exploit his employer's image. The point of the case of Rowe is that a speaker's employee cannot deliberately trade on public employment while claiming the speech is entirely unrelated. But NTEU would mean little if its protections could be circumvented by merely identifying the author as a public employee. So one of the lines of delineation here is that your conduct or your speech is hard to claim. On the one hand, it's purely private, and on the other hand, explicitly tie it to your employment as part of a public servant. You can't really have it both ways at the same time. So if you are saying that you are, in the case of Rowe, for example, you're saying that you're a police officer wearing the accoutrements of a police uniform and performing things using police pantomime, then your employer, the police, have a legitimate interest in that because you're making your employer look bad using the mechanisms of your office. So you're using your office to further your private speech, and they have an interest in that. So that's, you can't do that. If you're a public employee, you can't trade on your name in your private speech. If you could, for example, not mention that you're a public employee. You could not, in your videos, mention that, and then, that would be helpful. And you cannot wear the uniform of the public employee. That would be helpful. So, that's one of the things. If you tie it to your employment, your employer has an interest. One moment. I have to wait for the kitchen to be done. Okay, we're just going to camp out here for a second while I see if this audio is going to go away before I carry on. So we're just camping out, guys. How's life treating you? While I see if this background audio is going to disappear or not. I mean, I guess it's not like the biggest deal. I could just talk over it because when I'm talking, it completely blands it out. But ideally, I'd like to not pick it up at all. We're just camping. We could do an Ask Me Anything. You want to do an Ask Me Anything? Let's do an Ask Me Anything while we're waiting out for this. Ask Blackleaf any question about any issue. We're going to have an Ask Me Anything while we're waiting. So, ask me questions. Is it a dishwasher? I don't know. It might be a laundry machine. I'm not 100% sure. Yeah, you can't breathe from laughing so far. Yeah, that's definitely where we are on this. Any good Xmas gifts? Yeah, I got some new socks that were very nice, and what else did I get for Christmas? I'm trying to remember what else I got. Oh, I got some shirts. I got a really nice shirt that I was wearing in a different video with the buttons. I got those shirts and the sweater. That was really nice. And what else did I get? I'm trying to remember. Yeah, so it was good. It was a good Christmas. I got some nice stuff to wear, and yeah, it was good stuff. Why is the club have I ever been arrested? No, I've never been arrested. No. I was pulled over once for reckless driving by speed because Virginia is a bitch. If you're going more than 80 miles an hour in Virginia, it's reckless driving, which is a first-degree misdemeanor. First-degree misdemeanor for speeding. Virginia's insane. So I was once pulled over for that. That was annoying. I played it down to simple speeding, though, so what a pain in the ass that was. But never arrested. No. Why does the Clemson Tiger look like he's on drugs? I don't know. Maybe because the people who designed him were. Most important Supreme Court case I've covered. Wow. Most important Supreme Court case I've covered. Jeez, I've covered so many cases. It's hard to answer that. I mean, for me, like the most important Supreme Court cases. We talked about Wickard, so I guess Wickard v. Filburn. We talked about it in the context of Gonzalez v. Reich. So when we did the React for Team Trees, we did it for tree law. We did Gonzalez v. Reich, and we also read the opinion of Wickard v. Filburn, or at least the syllabus of it. And we talked about how much I hate that case so very, very deeply. So that would be an important case. Chevron is an important case. So those are like probably the cases we talked about that are the most important that have come up a lot. Will I really take the Texas bar exam without preparation at 10K subs? I believe I said 100,000 subs, not 10. And yes, I will take the bar exam without prep, because why not? It'll be fun. So, yeah. But, yeah. If I asked, you definitely lose your bot status. It's possible. So, did I get a new house? No, I'm moving. I am moving locations. So, I'm currently in my parents' house while I'm moving locations. So, I'm shutting down my apartment in Alexandria and I'm moving to Austin. So, I am here for 2 months while I arrange all that stuff. So, my parents have a house and therefore it makes it a little bit easier. So I don't have to do everything in one big go. So that's what I'm doing. I'm staying in my parents' house for 2-3 months while I move to Austin, Texas. So I will soon be a Texan. Very exciting. Would I eventually like to become a judge? Yeah, sure. Why not? I think it'd be great. I think I'd be very good at it because I'm extremely well educated on the law. And I think I'm fair. At least I have my doctrinal theory down very, very well. So, I'm fair in that respect. I understand, the fundamental bases for which I'm making decisions, from conservative originalist thought. And, so I understand, the rationales and underpinnings of that pretty well. And so that makes it easier to make decisions that are fairer in terms of applying principles that you understand. So that's good stuff. Oh, Lord. Evil Coleslaw. I keep seeing issues from my Virginia friends about it. Yes, there's a lot to cover. Yes, there's a lot to cover. I just haven't found really a good way to cover. As a Virginia resident, at least technically for the moment, until I guess fully moved to Austin, Virginia is still my place of legal domicile. Let's be very, very cute about it. Well, my place of residence is in South Carolina, but my place of domicile is Virginia. Huh. So yes, as a Virginia citizen, I take it very seriously. And yeah, I think there's a lot to cover. It's just trying to find a good way to do it because it's, a lot of news stories and a lot of stuff. It's trying to find a good way to do it. The only way I can think to do it is more Tim Pool-esque. And I'm not sure I want to become Tim Pool. So I could just do the news articles and I could do a Tim Pool thing, but I don't know. That's really my style. Then again, he has way more subscribers than I do. So, You might want to invest in sunscreen so I don't burst in flames. Why the prison orange shirt? Okay, well, you are getting timed out. So you are getting timed out. You are timed out for 300 seconds. Thank you for your question. All right. Fellow Texan, you can wave into Texas in license. Yes, I know I could wave in. But that's that's not fun. Where's the fun in that? Why not just take the bar exam again? Yeah. 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 So, yeah. Oh, Cherry asked a question. Yeah, about becoming a judge. Yeah, I'd like to become a judge. I think I'd be very good at it. Isn't becoming a judge easy? Just apply for open ballot position and become an incumbent. It depends on the state. Virginia doesn't elect judges, so I haven't been able to run for judge in Virginia because it doesn't elect judges. When I moved to Texas, which has elected judges, then possibly. I don't know that there's like just a whole lot of open positions for the hell of it, but yes, maybe. You have to defeat a current incumbent first. Yes. All right. I think the noise issue is sufficiently restrained, and so we will move on with the law story. Are you able to practice anywhere as a member of the patent bar? Yes. 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 That's a nice trick. See, because all my stuff is transactional before the patent office. And so, with few exceptions. So that's great. I can literally open shop anywhere in the U.S. There was a case out of Florida that decided this issue, like in the 80s. I forget the name of the case. Where a guy who was a patent lawyer who was registered before the patent office, but not a Florida attorney, opened shop in Florida, said attorney, for hire. And the bar came after him. The Florida bar came after him and said, well, you're an unlicensed attorney. We're going to prosecute you for unauthorized practice of law. You went to the U.S. Supreme Court. The U.S. Supreme Court told Florida to eat it because he was registered before the U.S. Patent and Trademark Office. So yes, I can be a patent lawyer anywhere. Bwah ha 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 ha. Bwah ha 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 ha. It's very exciting. Yes. Do I ever do requests to cover cases? All the time, Dustin. All the time I do requests to cover cases. Message me on Discord or message me on Facebook is probably the easiest ways to get my attention. But yes, I put 2 stories on the queue from like the last stream I did. And so yes, I take requests all the time. So yes, I will happily take your request. Please message me on Facebook or Discord and tag me, and then I'll see it and I will put it on my story list. Let's go back to the quick recap on the legal story. Yeah, the quick recap on the legal story is we're discussing a former sex phone operator turned AmeriCorps volunteer who was fired from her job at working for the National Guard because the lieutenant colonel fired her because of her book, and she's suing for First Amendment issues. So that is where we are in this case. Yeah. Conversations was speech on a matter of public concern within the meaning of NTEU, and Harrisberger is therefore entitled to the Pickering balancing test. The district court erred in reaching the contrary conclusion. That is not enough to resolve this appeal, however, as the district court ruled in the alternative that, even assuming conversations was constitutionally protected in the threshold sense, the Pickering balance weighed in the defendant's favor. This ruling, too, was erroneous. The challenge in public employment speech doctrine is to arrive at a balance between interests of the employee as a citizen in commentating upon matters of public concern and the interests of the state as an employer in promoting the efficiency of public services it performs through its employments. In deciding whether the balance should be struck in favor of speech or efficiency, we have examined 7 factors. So now we're getting into the balancing test. Assuming that there is a legitimate interest from the state, where is the balance between the two? And there's a multi-factor balancing test. So let's discuss. Whether the speech would create problems in maintaining discipline or harmony among co-workers, whether the employment relationship is one in which personal loyalty and confidence are necessary, whether the speech impeded the employee's ability to perform her responsibilities, the time, place, and manner of the speech, the context in which the underlying dispute arose, whether the manner was one in which debate was vital to inform decision-making, and whether the speaker should be regarded as a member of the general public. At trial, the public employer has the burden of showing by preponderance of the evidence that the balance weighs in its favor. Kropinski's first reason for doubting Harfinger's effectiveness was that conversations reflected poorly on the guard, but there's no evidence or reasonable inference that it had done so or would have done so, certainly not to the extent that it would risk compromising the guard's mission. So here, the speech would not compromise the mission because it was not related to, was not tied to, and otherwise was completely disconnected from her employment status. So there was no fear of it undermining the mission of the employer. Nate said, "Why move here to Texas? I visited Austin and I really liked it, and I can work from anywhere, so why not?" I've lived in DC for 12. I've lived in DC for 12 years. I've lived in DC for 12 years, and it's fine, but there's no particular reason for me to be there. So why not? I visited Austin and thought it was cool. So why not? It's like, the people I work with, my clients and such, they have no concern about where I live. It doesn't matter to them. It makes no difference. So there's no reason for me to be in DC. Hold on. Hold on. Yes, the taxes are also nice. I don't have to pay income tax anymore. State income tax. So I get more of my money for free. So I don't have to pay income tax anymore. So that's nice. Also, and this was most decidedly not going to be in the video on demand, but when I visited Austin, I couldn't help but taking notice of the many, many, many bars and such. And I thought to myself, I'm lonely and single, and I could go visit these bars and, I could find a woman who will love me, and that would be good. So, to find a bride is part of the goal, which is not happening in DC. So, in this case, there is no evidence and no basis for believing that veterans or organizations serving them would distrust the Guard if a known author of a phone sex memoir were permitted to collect and enter the organization's contact information into a database on the Guard's behalf. It is in fact highly unlikely that conversations could have reflected anything at all about the Guard, positive or negative. Well, Nate M. as to Austin and traffic. Let's talk about DC and traffic. So, yeah. In sum, the defendant's side of the Pickering balance is empty. The connection between the stated grounds for Harfinger's termination and the evidence before us is so tenuous as to support a reasonable inference that the former were merely pretexts for feelings of embarrassment and disgust that conversations undoubtedly and intentionally, Harfinger pointed out, aroused in its readers. Nice choice of the word aroused in this context, but okay, thank you, court, for playing. But a public employer may not use authority over employees to silence discord, not because it hampers public functions, but simply because superiors disagree with the content of the employee's speech. So that is the end of the case of Amy Harnessberger versus United States of America. In this case, we learned that Amy was a public employee as part of the government program for AmeriCorps, and that she was participating in helping collect data for veterans for various programs and such that they could rely on. However, her employer, the National Guard, found out about her prior work as a phone sex operator and fired her because of her speech in her book. The Court of Appeals is noting here that the conduct in question did not concern her employer, did not involve her employer, did not implicate her employer, and was otherwise untied to the mission of the employment, and so there was not a valid reason to fire her because this would fall into the context of protected First Amendment speech in the balancing interest that we saw about, and that is the end of this case. I also liked all right, I'll tell you the story too. I'll tell you about the one thing. I'll tell you about the one thing that really sold me on Austen. All right. So, in the books, Winnie the Pooh, there is a character called Eeyore, the donkey. And one of the shticks of the book is that people forget Eeyore's birthday. And so, the residents of Austen, sometime in the late 60s, as is evident from the event, decided they would fix this problem. They would annually hold a party for Eeyore's birthday. It is called Eeyore's birthday. It is a festival devoted to Eeyore, ostensibly. And I went to this event, and I don't know if any of you guys have ever been to a Renaissance fair, but in like terms of like the costumes, in terms of like the sort of otherworldliness of it, if you could multiply that by like, I don't know, 5 times, you get a pretty good idea of what we're talking about in terms of Eeyore's birthday. It was, by far and away, the strangest thing I've ever been to in any context ever. The fact that there were topless women walking about was the least strange thing about it. I think it's quite possible that I got a secondary contact high from all the drugs. All the drugs. There were lots of people at this event. I mean, 10,000, 20,000 people at this event. It was in a massive national park, or massive park. And there were like people everywhere and food everywhere, and like there are people dressed in all kinds of costumes, and it was surreal. And I feel like I have to go back and live it to fully understand it. I feel like I need to understand what the hell this is. My conservative mind doesn't fully comprehend what it is I saw. I feel like I need to go back and understand more and live Eeyore's birthday as a life experience. So I'm going back for Eeyore, man. It was strange. Yeah, I figure it will help me with my bohemian beatnik shtick that I would like to develop. You know, I've been doing a lot of improv comedy classes, which I really like, and I figure, you know, it's a very artsy kind of community, and it will help me expand my horizons in new and interesting ways. So yeah, yeah, that's a good time. Yeah. So, oh Lord, yeah, it was a interesting experience, man. Yeah, yeah. So I figure I'll go and meet a hippie girl and fall in love, and it'll be great. That's now the working plan. All right. If you go on Instagram and Google Eeyore's birthday, you can see some pictures, man. It was an interesting experience. it was strange. Yeah. Yeah, Google image search did not disappoint. I bet it didn't. Yeah. Yeah, it was, yeah. Oh, man. It's nothing compared to Piglet's cotition. What the hell is that? Dustin, I must know more. I must know more. Is that a real thing? If it is, I'm in. If it is, yeah, I must know more. Tigger's bar mitzvah. All right, let's carry on. Hello, everyone, and welcome to Uncivil Law. For today's case, we're discussing the case of Dustin Ayala versus Michael Hoxton. This case deals with an excessive force complaint by the police. In this case, the police maced someone without sufficient cause, and so the Court of Appeals is being asked to analyze this. So let's read this and hear on and see what is being decided. So let's read on and see what is happening in this case. In May 2016, Hoxton went to Ayala's mobile home in Greenup County, Kentucky, to serve him with a court order. Hoxton banged on the front door, but no one answered. Ayala had been in bed, but got up and started to dress when he heard the noise. He peeked out of a window, saw a deputy at the door, and told his girlfriend to get the cell phone and start filming. Ayala thought he heard the deputy trying to turn the front door handle, then heard the same sound at the back door. By that time, Ayala was dressed. He stepped out on the front porch and called to Hoxton. Hoxton then came back to the front of the home and handed Ayala a court order. The cell phone video starts there. For the first 8 seconds, it shows the two men shouting profanities at each other, with Ayala standing on the porch about 3 feet above the ground, and Hoxton a few feet away at the bottom of several porch steps. Ayala accused Hoxton of trying to enter the mobile home and yelled at him to leave. Hoxton cursed right back and told Ayala to come down here, boy. Ayala continued to swear and appeared to point or wave his hands toward Hoxton several times. At the 8-second mark, Hoxton told Ayala that he was under arrest for menacing. At the same time, he sprayed Ayala in the face with 2 bursts of pepper spray. Hoxton then told Ayala to put his hands behind his back, which he did without protest. Then, without handcuffing Ayala, Hoxton took him off the porch, across the driveway, and into the backseat of a cruiser. So here we see that there was 8 seconds worth of interaction. There were some mean words expressed. The police decide to charge someone with menacing, and then decide to mace someone else for no particular reason. Let's read on. The local district attorney charged Ayala with menacing, a state law misdemeanor. A jury acquitted him. Ayala then sued Hoxton and the sheriff's office under 1983 and state law, alleging, among other things, that his arrest had been unlawful and that Hoxton and the sheriff's office then moved for dismissal based on qualified immunity. The district court denied the motion, and this appeal followed. So here, there was a lawsuit for 1983 for deprivation of civil rights. The police moved to dismiss on the basis of qualified immunity, but the district court said no, we're not going to dismiss on the basis of qualified immunity. This has to go forward. And so we're at the appeal stage to see if qualified immunity should be given. Hogston argues that he had probable cause to arrest Aiea and therefore is entitled to qualified immunity on the unlawful arrest claim. Hogston says he had probable cause to arrest Aiea for menacing, which a person commits when he intentionally places another person in reasonable apprehension of imminent physical injury. Hogston also argues he was entitled to qualified immunity on Aiea's excessive force claim. The Fourth Amendment protects citizens from excessive force by an arresting officer. Accordingly, an officer may not use pepper spray on a detainee who is not under arrest, is not resisting arrest, and has been subdued. Here, the video shows that Hogston pepper sprayed Aiea at the same time Hogston arrested him. Thus, Aiea lacked any opportunity to resist arrest before the spray, and the district court found there was no evidence that Aiea was behaving in an aggressive, threatening way. Taken in the light most favorable to Aiea, the facts therefore show the use of pepper spray was excessive. So here, the police officer is putting you under arrest and at the exact same time is pepper spraying you. And the pepper spray is improper because there's no resist to arrest. There's no threat. There's no force. They seem to be compliant, and yet you're pepper spraying them. But the courts have said this is not proper. You can't do this. You can only use pepper spray when there's a need, and there was no need here, so that makes it excessive force. The decision of the district court, therefore, is affirmed. Short one today. Short, sweet, to the point. So that is the end of the case of Dustin Aiea versus Michael Hogston. In this case, we learn that Michael Hogston came to serve some court papers, and that some mean words were exchanged, and that some cursing then occurred. And the police officer decided to arrest them for menacing, but then made the critical error of pepper spraying them, even though there was no resist to arrest or other threat going on, and so it was excessive force. So the Court of Appeals agrees. The case law is clear on this issue. Therefore, there is no qualified immunity because the case law has been clearly established. This will go back to the district court for further factual findings and damages, and that is the end of this case. Okay. Let's see if this is gonna work. Hope you all are having fun. I'm gonna get myself a Texas cowboy hat. I'm gonna have to have it custom made because I have a big ass head. I'm gonna get myself a Texas cowboy hat. I'm gonna learn some line dancing. I'm gonna get myself a beret. I'm gonna become a beatnik. I'm gonna read bad poetry at coffee shops and pontificate about stuff. I have a plan, man. It's gonna be great. Railway hacker, the phrase you're looking for there is eggshell skull. Eggshell skull is the phrase you're looking for there. All right, so let's see. Hope I feast on all the brisket. What about snakeskin boots? I don't know if snakeskin is really my style. I'm not really. I don't think snakeskin's really my style. But we'll look into it. Bolo tie, yeah, bolo tie will do. I don't know about the snakeskin. I'm not really feeling it. Have I read On the Road by Kurzak? Not that I recall doing so. Yeah, I'll become a judge with these videos being part of my campaign. Could well be, man. Texas people will like that, Hi, y'all. My name is Blackleaf. Y'all here? This is me line dancing. This is me took a booty right over the criminals out there that need to be showed respect. Watch me get my belt, man. I'm gonna pull my hat. I'm Black Thief. Vote for me. Superior Court Judge. Yeah. 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 Hello, everyone, and welcome to Uncivil Law. For today's case, we have the case of Karen McNeil versus Giles County, Tennessee. In this case, we're talking about bail and the requirements of bail, and bail that is being set too high that people cannot pay it and therefore are being held in jail, even though they shouldn't be because they simply can't afford bail. And this is a problem in the United States, and we're going to learn about one such problem that occurred in Giles County, Tennessee, and how the Court of Appeals is being asked to adjudicate it. And so let's get started with this. Don't break my heart, my achy breaky heart. Don't understand. If you break my heart, my achy breaky heart. Might grow up and might. Several criminal defendants believe the way Tennessee sets the amount of bail for misdemeanor crimes violates federal due process. Under Tennessee law, a county sheriff enforces probation violation warrants, and the bail amounts are established by state law and set by a local judge. The district court granted the probationers a preliminary injunction against the county and sheriff's enforcement of the bail requirements. The county and sheriff do not challenge the preliminary constitutional ruling. They argue for now only that the probationers should have sued the state judges who determine the amount of bails instead of suing the county and the sheriffs who enforce them. We affirm. So here the district court granted a preliminary injunction, which is, while the case is pending, it's not a permanent injunction, but, while the case is pending, granted a preliminary injunction that prevented them from enforcing certain of these things because of the unconstitutionality. The Court of Appeals is affirming and saying that, yes, the district court couldn't do this injunction, and they're going to discuss a little bit more as to why. Dustin, I am so in. On the Road. I'm putting it on my ever-growing reading list. My reading list is even worse than my cases to be discussed list. I mean, it just goes on and on and on endlessly. It's just so much stuff on my reading list. But I will put it on my list. Thank you for the recommendation. On the Road. Yes. It's only $10 paperback. That's not bad. Just add this my that's my Amazon cart. Okay. All right. Just one claim matters today. The probationers say the county and sheriff violated their substantive right against wealth-based detention by detaining them after arrest until they paid bail. The problems, say the probationers, is that judges set the bail amount without reference for a person's ability to pay outside the person's presence and without determining whether the person poses a danger to the community or a risk of flight. If a judge decides to set bail, Tennessee law requires that the amount be set as low as the court determines is necessary to reasonably assure the appearance of defendant as required. It also spells out the things the judge must consider in determining that amount, including how long the person has lived in the community, the prior criminal record, and financial condition. The first opportunity to convince a judge to lower bail takes a few weeks. General Sessions Court's arrestees receive their first court appearance within 10 to 14 days, but may not challenge the bail amounts until a second court appearance 10 to 14 days after the first. Circuit court arrestees appear in court on one designated day a month, meaning the county detain them for up to 30 days without a challenge to the bail amounts. So that is pretty interesting indeed, that, it can take 30 days for a person to be able to challenge a bail amount that was set without them being present in the first place and was set without taking into consideration the factors. All these things do seem like violations of due process to my mind. You'd want this to be done much faster. You want it to be done in the presence, and you want it to be done with consideration of the factors. And so the fact that it's not being done here is problematic at minimum. Tennessee law suggests that Sheriff Helton acted for the state when he enforced the bail amounts. The Tennessee Constitution creates the office of the county sheriff. Therefore, the lawsuit may also proceed against the county for now. The county does not deny that it employs the sheriff, nor does it deny the sheriff's involvement in the child's detention, nor does it claim it acted against its commands when it detained the plaintiffs. The county, if it's true, may be able to raise defendants to this 1983 claim. It may be able to show, for example, that no constitutional violation occurred or that county policy or custom did not trigger it. But few considerations counsel against resolving that defense today. That's the end of the case. So that is the end of the case of Karen McNeil versus Giles County, Tennessee. In this case, we learn that in Giles County, judges are setting bail without proper consideration of the factors set out. They're not considering the ability to pay, and they're not considering the amount that will take need for the people being able to show up. It's disconnected. And if you want to challenge the bail amounts, you can't do so for 30 days, which seems like a due process violation. And so the preliminary injunction that prohibits the sheriffs from enforcing these orders is allowed to stand as further discovery goes forward into what actually occurred at the county, and that is the end of this story. Bye, Manitoban. Sorry you have to leave. It makes me very sad. Let's see here with Michigan. Hello, everyone, and welcome to Uncivil Law. For today's case, we have John Doe, 8 through 10, versus Rick Snyder, the former governor of Michigan, and various administrators of prisons, wardens in the state of Michigan. In this case, John Does are prisoners, and they're accusing the government of not giving them due process when it occurs to reporting sexual assaults that occurred inside the prison. They're saying that they were denied due process and forced to undergo labyrinthine procedures that were designed to discourage them or prevent them from filing their complaints, and so they're bringing suit for violation of their rights in that respect. So we're going to read the case and see what it has to say. The Prison Litigation Reform Act requires inmates to exhaust The Prison Litigation Reform Act requires inmates to exhaust available administrative remedies. The Supreme Court has explained that the Litigation Act contains its own textual exception to this mandatory exhaustion. Under the statute, exhaustion requirement hinges on the availability of administrative remedies. An inmate, that is, must exhaust all remedies, but need not exhaust unavailable ones. The question here is where the administrative remedies provided to inmates by the state of Michigan are available. In the case before us, they are not. As the experience of John Doe 8 and John Doe 10 show, the Michigan Department of Corrections administrative process is in practice filled with contradictions, so much so that we hold it as unavailable. The plaintiffs, John Does 8 through 10, are inmates in various Michigan prison facilities. At one time, the Does were juveniles housed with adult inmates, a policy that Michigan has since abandoned. The plaintiffs bring 1983 claims that stem from alleged sexual abuse by adult inmates, which occurred when the policy of housing juveniles with adults was in place. So here the allegation is that juveniles were being kept with adults in adult prison, and as a result they were being exploited, and they want to bring a complaint for not protecting them. Now, while the state in general has no affirmative duty to protect people in general, they do actually have an affirmative duty when it comes to prisoners because they cannot protect themselves. So the state does have an affirmative duty to protect prisoners, and if they're being maltreated, then they can be liable for that. So let's read on. The Department of Corrections adopted a grievance procedure pursuant to the Prison Rape Elimination Act. The Prison Rape Elimination Act generally left intact the Litigation Reforms Act exhaustion requirement, but regulations promulgated pursuant to the Prison Rape Elimination Act modified one aspect of the exhaustion. The Department of Justice issued a final rule mandating that an agency shall not impose a time limit on when an inmate may submit a grievance for allegations of sexual abuse. In order to understand whether due process was given or not, we need to understand more about Michigan's process, both in general and as it applied to these particular inmates. So let's read a little bit more. In 2016, Michigan instituted a two-step Prison Rape Elimination Act grievance process for sexual abuse claims. At step 1, an inmate must submit a grievance form to the coordinator or an inspector at the facility in which an inmate is housed. Then, an inmate may only file a Step 2 administrative appeal to the administrator if they're dissatisfied with the response received at Step 1 or they did not receive a timely response. So here there's ostensibly a two-step process. First step is make an initial report to an initial administrator, give them a chance to cure, and if you're not satisfied, then you can appeal. And presumably you could then go to court after that, after you've exhausted your administrative remedies, but you give the prison a chance to correct the problem first. With that background in mind, we turn to the experiences at hand. In 2016, Doe 8 filed a grievance based on a rape and sexual harassment that he experienced while in prison. After that, Doe 8 received from the Department of Corrections a memo that stated his complaint would be treated as a Prison Rape Elimination Act grievance. On June 13th, Doe 8 received a response from the coroner. The response stated that his Prison Rape Elimination Act grievance has been received and reviewed, that he be notified of the outcome of the investigation at the conclusion of the investigation, but also, although the investigation is pending, the grievance is considered responded to and closed. If you're having a difficult time figuring that out, so am I. It's both pending and closed at the same time. Magic. Doe 8 was unsure about what the response meant. In the absence of any indication from the Department of Corrections as to which of the two contradictory statements in the response were true, Doe 8 nonetheless filed a handwritten Step 2 appeal on June 7, 2016, after he requested a Step 2 form but received no response. At oral argument, counsel for the state represented to the court that July 18th investigative findings and actions form is neither a Step 1 nor Step 2 document. Rather, it's the termination of the process. Yet also at oral argument, counsel for the state responded that Sergeant Bellinger would have been one of the investigators, and counsel did not think that he was an administrator. So even at the appeal, the counsel for the government is unable to clarify exactly what the status of this thing is. They're not able to clarify what's going on. And they're saying the person who's investigator is not an administrator for this purpose. So they're not handling it the way it should be handled. Doe 10 filed a grievance based on sex abuse and harassment that he experienced at various Department of Corrections facilities. On June 8th, 2016, Doe 10 received a memo stating that his complaint would be processed as a Prison Rape Elimination Act grievance. Doe waited for a response but never received one. Accordingly, Doe received a grievance appeal form sometime in early July, but Doe claims he never actually received any form. Let me do that line again. Accordingly, Doe requested a grievance appeal form sometime in early July, but claims he never received any form. So it looks like the state wants to have its cake and eat it too. You know, they don't want to process the forms. They're putting up all these road barriers and blocks. They're not giving a fair process. So what does the Court of Appeals have to say? Looking at this record, the state's administration of the Prison Rape Elimination Act's grievance process is a classic case of Orwellian doublethink that falls comfortably within circumstances outlined in Ross versus Blake. Examples of such contradictory statements abound in the record, and inmates need not navigate this labyrinth world of doublethink to satisfy the exhaustion requirement. The examples show in practice no ordinary prisoner could discern or navigate the process, and the process was designed to trip up all but the most skillful prisoners. The Department of Corrections stated the investigation of a grievance is pending, and an inmate will be notified of the outcome at the conclusion, while simultaneously stating that the grievance is responded to and closed. In the defendant's view, the grievance is both pending and closed, and that makes no sense. A prison official inaccurately described the process to Doe. The department regulations require an inmate to appeal the Step 1 decision to an administrator in a central office. Doe 10's grievance coordinator, however, attempted to appeal and told Doe to send it to the SRF, not to the central office, and gave Doe the wrong information. The Investigative Findings and Action Forms is a prison rape elimination action form, yet it is neither a Step 1 nor Step 2 document. That form is apparently the termination of the investigation into the grievance, but again, it's not a Step 1 response that can be appealed, and this confounds the confusion. Clearly, the Michigan Department of Corrections Prison Rape Elimination Act grievance process is, in practice, filled with contradictions and machinations, and these contradictions and machinations render the process incapable of use. So that is the end of the case of John Doe's 8 through 10 versus Rick Snyder, former governor, and various prison wardens. In this case, we learned that the state of Michigan had a labyrinthine Orwellian process, in the words of the Court of Appeals, in order to file complaints under the Prison Rape Elimination Act, an act that was designed specifically to deal with this. And they had all these problems and misinformation and were denying people and telling investigations were both open and closed, and so forth and so on. So when they went to court and argued about this, the initial response from the government was they didn't exhaust their administrative appeals. They have to exhaust their administrative appeals. But the Court of Appeals says they don't have to exhaust administrative appeals that don't actually exist. You guys made it so impossible to comply with these rules in any meaningful way that they don't really exist. So you can't force them to comply with stuff that is impossible to comply with. And as a result, you can go to court and seek further action. So this will go to court and seek further action for redress for these alleged violations. And that is the end of this case. All right, let's move on. All right, we're going to do 2 for today, I think. Yeah, we're going to do 2 for, okay. All right, this is our last story, guys. Hello, everyone, and welcome to Uncivil Law. For today's case, we have a pending matter before the Court of Appeals for the D.C. Circuit. This is the Committee of the Judiciary in the House of Representatives versus Don McGahn. In this situation, we're learning about the subpoena for Don McGahn to participate in and appear as it relates to the impeachment hearings. As you may remember, the impeachment was voted on. And so one of the issues the court of its own initiative asked to be briefed on, because the oral arguments are now set for January 3rd, one of the issues the court asked to be briefed on was whether or not the subpoena was moot. because the subpoena was issued by the Judiciary Committee for testimony as it relates to the impeachment. The impeachment has been voted on, so maybe the matter is disposed of. Maybe this issue is moot. And so we're going to review two briefs on this issue. We're going to review a brief from the Department of Justice, and we're going to review a brief from the House itself, which indicates that it may not be over because additional articles of impeachment may come. We're going to have another impeachment vote, basically, is what the House is telling us. So that's super exciting. So let's get started with this. First, we will turn to the Department of Justice's complaint. First, let's turn to the Department of Justice's filing. Pursuant to this court's December the 18th, 2019 order, the Department of Justice, on behalf of appellant Don McGahn, files a supplemental brief addressing the effects of the article of impeachment on the issues in this case, including whether the articles of impeachment render this case moot and whether expedited consideration remains necessary. In its complaint, the committee alleges that, wholly apart from the impeachment proceedings, McGahn's testimony would assist the committee in assessing the need for remedial legislation and to conduct oversight. Although the suit is not moot, the impeachment vote affects the extent to which the expedited consideration remains necessary. The committee opposed the department's request for a stay pending appeal because the delay from such a stay would impair the House's ongoing impeachment inquiry. In doing so, the committee stated that speedy judicial action is needed to avoid hampering the House's impeachment investigation. And that justification no longer applies. The articles of impeachment affect this case in two other ways. Before the impeachment vote, the committee had no response to the department's point that a court, as a matter of equitable discretion at a very least, should refrain from entangling itself in an inter-branch dispute when Congress as a whole has not made a conscious choice to clearly grant the court's subject matter jurisdiction over the committee suit and a committee cause of action to sue at all. The reason for refraining are even more compelling now that what the committee asserted, whether rightly or wrongly, as a primary justification for its decision to sue no longer exists. The articles of impeachment addressing the purported obstruction of Congress relies in part on judicial proceedings in this very case. The House Judiciary Committee impeachment report, for example, cites the district court's characterization of the Justice Department's litigation position in this case for the proposition that the president insists on unfounded doctrines, such as absolute immunity, precludes the testimony by many current and former officials who may shed light on presidential abuses. Pursuing an inter-branch suit in court while simultaneously pursuing impeachment and then using that litigation as part of the impeachment proceedings is far from the traditional model of common law's cause of action at the conceptual core of the case or controversy requirement. So one of the things that they're pointing out in this brief is that the contempt of Congress argument has been predicated on part of the litigation in this very case in the courts, arguing that that itself comprises contempt because they're not going to Congress, they're instead going to the courts. Now, personally, I would say two things. First of all, contempt of Congress in this context is unclear. And second of all, going to court to argue against the injunction or asking the court to rule on it is part of the perfectly normal process of how these things are handled. You know, the executive branch has many times denied people going to the legislature, and what they do is they go to court and force the issue. You know, and so this is like typical. So to argue that's obstruction when it's part of the typical process is a bit unusual at the minimum. So that's one of the things they're talking about. But wait, there's more. There's also the brief from the judiciary, the House itself, where they make different arguments than the Department of Justice as to its interests. So let's read on about what the Congress has to say about it. According to Congress, no, let's try that again. The Judiciary Committee writes, this case is not moot, first because McGahn was a witness to several of the president's past efforts to undermine investigations into foreign interference in elections, which relate directly to the obstruction of Congress article of impeachment. McGahn's testimony is also relevant to the committee's ongoing investigations into presidential misconduct and consideration of whether to recommend additional articles of impeachment. So anyone who was hoping that the impeachment vote meant that the impeachment is over, I think we were all fools for thinking that, because the House has indicated that they're looking at additional articles of impeachment. So they've impeached the president once, they're going to impeach him again, impeach him a third time. So we're going for multiple impeachments. It's the first president in history who's going to be impeached. So now the betting pool is not on whether the president will be impeached, but how many times will he be impeached? That is the only issue relevant to continue to discuss. So we're going for multiple instances of impeachment. That's super exciting for all. It also means that there's a precedent that's now set that we're just in continuing impeachment inquiries. I once half joked that the Senate would announce any day that their impeachment inquiry into the yet to be determined next Democrat president of the United States would begin any day now. Because why do we need to know who they are in order to impeach them? So maybe now impeachment will just become another thing that's continuously happening for both Republican and Democrat administrations perpetually, and this has just never stopped. So this is the new hell we're all welcome into. Welcome to your life, I suppose. McGahn's testimony is vital to the House ongoing impeachment proceedings in several respects. McGahn's testimony would inform the House's decision-making regarding the presentation of articles and evidence in the Senate. Personally, I would think that you would already know that by the time you voted on the articles. You'd already know the case that you're going to be presenting, and you're like, we're ready to present. You're like, no, but we're not ready to present. It's like, but why did you vote on them then? The whole thing is so weird. It's like a prosecutor going to court and saying, I have this indictment, but I'm not ready because the FBI is still investigating the case. It's like, what are you talking about? You should, the investigation's over. We're ready to go forward. What is this? As the committee has explained, although the second article of impeachment focuses on President Trump's categorical and indiscriminate obstruction of the House's impeachment inquiry, the consistency of this obstruction with broader patterns of misconduct is relevant and striking. The pattern includes the fact the president sought to curtail the special counsel's investigation in a manner exempting his own prior conduct and instructed the White House counsel to create a false record and make false public statements. The committee thus continues to have an urgent need for McGahn's testimony to further support the misconduct described in the second article. For example, if McGahn confirms to the committee the president ordered him to fire special counsel Mueller, an event President Trump has publicly disputed and then tried to cover up, that testimony would constitute powerful evidence of a pattern of obstructive behavior described in the second article. If McGahn's testimony produces new evidence supporting the conclusion President Trump committed impeachable offenses that are not covered by the articles approved by the House, the committee will proceed accordingly, including, if necessary, by considering whether to recommend new articles of impeachment. Strictly speaking, this is not fair use, but hold on, I'm putting this in here because I feel it's hold on. So So that is the end of our coverage of the briefs in the ongoing case to be argued January 3rd in the District Court of this Court of Appeals for the District Court of Columbia in the case of Committee of Judiciary versus Don McGahn. In this case, we learn that Don McGahn is still being asked to testify. The DOJ says it's relevant to some issues, but not really relevant to others. And the House says, no, actually, we want to impeach the president many, many times. Our impeachment isn't over. We want to do more. We want all the impeachments. So I think we can look forward to many, many more impeachments to come. And that's just the end of this story. All right, guys. Whew, that was a good one. So, yeah. So, yeah. That is the end of it. I hope you enjoyed our stream. We've been here for 2 hours. There were technical issues and lots of stuff. But yeah, we had fun. I hope you had fun too. So, yeah. That's it. Hope you have a good Sunday, guys. If you haven't already done so, I'd appreciate it if you gave the stream a like. 26 of you are watching. There's a little thumbs up button just below the screen, a little thumbs up button. If you gave the thumbs up, I would love you forever. So I'd appreciate it. Yeah. So we'll do more. Oh, and as always, I'm going to set this as unlisted, so it'll be in your history, but not in the feed. So I will do that now. Just change the status to unlisted, and I hope to see you all soon. Bye.